Brian Walshe attorney Larry Tipton, along with other defense attorneys who are currently representing defendants who have been investigated by one Michael Proctor, the former McAlbert consigliere, are requesting to stop the destruction of his iCloud account before it gets yeeted into the federal ether. But as you know, folks, in every story there is a villain. Only this villain comes in the form of ground beef. Hello, and welcome back, roommates, to another titillating edition of Alexasrewm, where we are not lawyers, we are not medical professionals, and we are not law enforcement. We are just people. People who have opinions about all things going on post Karen Read verdict, including this story that broke earlier today from the desk of WCVB's David Bieniek. Attorneys for several criminal defendants are asking courts to stop the destruction of electronic records from a former Massachusetts State Police trooper, Michael Proctor, who lost his job in the wake of his testimony during Karen Read's first trial. I don't know why the article is jumping, but ladies, it's best to leave your man at home because it's 5:32 Central and the article is jumping. Data from Proctor's iCloud account was obtained during an FBI investigation into the handling of the O'Keefe unaliving case. I wonder if he's also got a fun burner email address. We already know Meatball's got his claims on Cheesy Banana, but something like Thin Blue Loin at iCloud.com. A federal court order mandated that the destruction of the records 30 days after the conclusion of Read's case, which would make that today, but attorneys representing defendants in other cases investigated by Proctor are arguing they only learned of the imminent deadline Thursday. So this is the Commonwealth's notice regarding materials subject to federal court order in the Brian Walshe case. So again, I'm assuming this is the same copy and paste template that they sent to everybody on whatever group thread that they were emailing this to. Now comes the Commonwealth and the above captioned matter and respectfully provides notice that pursuant to an order of the United States District Court for the District Massachusetts, yada yada, all confidential materials produced exclusively for the prosecution of Commonwealth versus Karen Read will be destroyed or returned to the federal government on July 18th, 2025, in compliance with the federal court order. I feel like it's typically standard practice to give at least 2 weeks' notice. I mean, you got to do that typically as a common courtesy in corporate America. Why not have that translate from industry to industry? Especially when you're dealing with something as permanent as, I don't know, destroying potential exculpatory evidence that could be useful to a defendant who's being tried for first-degree unaliving. Pursuant to the federal court order, the confidential materials, including any electronic copies or work product notes, are required to be destroyed as the materials are the property of the United States Attorney's Office and Federal Bureau of Investigation. Meatball, dated July 17th, 2025. So I'm fairly certain everybody was working really late last night, and there's a reason why Morrissey wants to comply with this order. Something else of note that a couple of people noticed is the signature down here doesn't resemble past signatures of Michael Morrissey. I don't want to go all Alice in Wonderland and go down the speculation rabbit hole too deep, but on the same thread by Suspicious Sauce on the Twitter X's, who shared this notice of discovery, also shared the signature from the letters from the DOJ. So you can see down here, and that looks significantly different than whatever chicken scratch was scribbled on that notice. So is there tomfoolery being had? Your guess is as good as mine. Also along for the ride is Rosemary Scapicchio, who helped to exonerate Sean Ellis, who was wrongfully convicted for the unaliving of Boston police officer John Mulligan back in '93. So this could get interesting. If they have copies of emails on Trooper Proctor's iCloud that they're aware of, that they have custody of, once we ask for them, they have an obligation, which again doesn't seem to be like the Commonwealth style. They don't have to turn over the actual email, famous last words, you might want that metadata, just saying. But they absolutely have to turn over exculpatory information within the email to us, said defense attorney Rosemary Scapicchio, who represents 2 homicide defendants investigated by Proctor, so she's getting a twofer.
To call the white woman the C word. What do you think he's calling black and brown people? That's what we're worried about. What do you think he's saying? Why are they so intent on destroying this information? All we wanted to do was preserve it so that we could look at it, so the district attorney's office could look at it.
In court today, the district attorney's office promised not to destroy any of Proctor's communications for at least 1 more week while they try to get more guidance from the feds. Now, during Reed's first trial, Proctor testified that he wrote the text messages because he was upset about the death of a fellow police officer, John O'Keefe. Defense attorney said outside court that Proctor has been involved in at least 24 other criminal investigations that are now in various stages of prosecution. Live in Dedham, David Bienick, WCVB.
Sorry, Davey. I just like Bienick a lot better. It just really, it's good for the sinuses. But anyways, 24 cases. So what I'm gathering is they had this hearing earlier today, and the judge is giving them a week to figure this out, get more information from the feds to see what, if anything, can be done to preserve these copies. These aren't the OG files, right? These aren't the X files. These are the copy of the X files. And that's what the defense attorneys want access to. They didn't know this deadline was coming up, according to them. And we're going to go through actually a motion that was filed by Larry Tipton, Brian Walshe's attorney, outlining this very thing. I do wonder if he continues to add more dates to this redemption tour he seems to be on. If he's going to try and use the same excuse that he used to explain away the derogatory text messages he sent to his buddies about Karen Reed. Because I'm sure that all of these dozens of other cases and defendants that were investigated aren't all police-related deaths. So how are you going to potentially explain away what, if anything, is found in regard to that? And I'm not saying that there is. I don't know. But I don't feel like this is the first time these types of conversations have been had by this man. And I can only imagine what he may have said about Anna Walshe and some of the other female defendants or victims in cases he was a lead customer service representative of. So, in Norfolk County Superior Court on Thursday, discussion reveals that the order itself is confidential. The judge requested a copy of the order and urged the defense attorneys to seek relief from the federal judge who issued it. But by confidential, you mean confidential to the public, right? Not confidential to the other parties who, it sounds like, didn't even get to see this order. So does an order even exist, or is this just something that's been reimagined by the staff working at Meatball's Palace? Also, the way that they're ominously referring to Michael Proctor's iCloud account, it makes it sound like it's Regina George and her burn book.
This girl is the nastiest skank bitch I've ever met. Do not trust her. She is a fugly slut.
Right, so then this is Larry Tipton, not to be confused with London Tipton's father from Disney Channel's Sweet Life of Zack and Cody, the defense attorney for Brian Walshe. His response to Meatball's notice. And this was also filed yesterday. Accordingly, the defendant, Brian Walshe, requests the court order that, 1, the Commonwealth be ordered to not destroy but maintain a copy of the federal materials referenced in the notice before returning a separate copy of the federal materials at issue. Now it seems like, according to today's hearing, that they have a week to figure this out. 2, that the Commonwealth be ordered to conduct a review of the materials at issue for exculpatory evidence relevant to Mr. Walsh's prosecution. 3, that the Commonwealth be ordered to compile a list specifying what materials were in fact produced pursuant to the federal protective order. Exactly. It seemed very vague from what we read before. 4, that the Commonwealth be ordered to provide a copy of the protective order and any attachments or lists of materials produced. Exactly. So it's like, how do we know this order even exists? We can't take your word at face value here. 5, that the Commonwealth file notice that a complete review pursuant to Mass Crim P14 for exculpatory evidence has in fact been conducted. Yeah. Show us your taint. With specifics as to who conducted and when the review was conducted. And 6, immediately produce any exculpatory evidence contained in the federal materials. Remember that interview that Turtle Boy did with Alan Jackson where he pretty much insinuated that there's probably stuff that they still didn't get their hands on. There's probably still tons and tons of exculpatory evidence that the Commonwealth is currently sitting on, revolving around that case. As grounds, therefore, in these circumstances, Mr. Walsh's case has a state and federal constitutional right to have materials in the possession of the Commonwealth examined for exculpatory evidence, as that term is now presently defined by the recently amended yada yada yada. The NCDO has been in possession of the materials for over a year. Right, so you had a whole year to get your taint all up in that. The NCDO cannot insulate itself from its duty to conduct a constitutionally based search for exculpatory evidence relevant to Mr. Walsh, where such evidence was produced in the context of an unrelated case where the documents are A, possessed by the NCDO, and furthermore, B, ADA McLaughlin, I was wondering when her name was going to pop up again, is a signatory to the protective order and a prosector assigned to prosecute Walsh. In support of this motion for relief, I, Larry Tipton, state the following to be true to the best of my knowledge and belief. I, along with Attorney Kelly Porges, represent the defendant, Mr. Brian Walshe, in this matter. Counsel was notified of this issue this morning by voicemail. So the notice was at least dated yesterday. Now it really does make me think, like, that signature didn't look like anything we've seen before from Morrissey. So somebody fudging something from one of the assistant district attorneys assigned to this case. So I'm assuming not McLaughlin. We later talked by telephone. The Commonwealth represented in the telephone call this morning that he understands, probably the head cheese. The order to destroy or return materials is contained in the original federal protective order issued last year, triggering a 30-day destroy or return requirement based on the date of any verdict in the event no appeal has been filed. So a couple things to unpack here. One, what is it with these 30-day auto deletion deadlines? Number 2, destroy or return sounds like a Metallica album. One I would very much like to hear. But also, they're talking about a federal protective order that was issued last year. So is this even relevant to this trial? And when was this order issued? Was this order issued before the first trial? Because that would make more sense. I have questions. I mean, they're just assuming that all of these attorneys knew about this federal protective order, but you can't know what you don't know. Commonwealth also represented that he does not know what the materials produced to the NCDO at issue are in fact since he was not a signatory on the protective order and has never reviewed them. So you're just speaking out of your butthole. The parties agreed that at a minimum, Michael Proctor testified before the federal grand jury investigation of the Reed matter. Counsel filed a 2-way request for federal materials, but that request was denied. In summary, the United States Attorney Office denied our request by stating, 1, it was not aware of any statements by state or local law enforcement in the possession, custody, and or control of my office or the Federal Bureau of Investigation that concern the investigation of Mr. Walshe for his wife's unaliving or the Walshe unaliving case. That some of our requests failed to meet the specificity requirements of yada 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 or fall within one of the exceptions to production in yada yada yada. And that some of the requests, if responsive, would have been complied for investigative purposes and would interfere with an ongoing investigation. Counsel believes that any federal investigation at issue in the Reed matter has ended based on media reports and representations made in court. Is it closed or is it not closed? Because you made a big fat stinking spectacle on national television broadcasting that it was. Which, to quote Karen Reed, feels all smoke and mirrors, in my opinion. I mean, this to me feels like there is something that's still going on. After speaking on the telephone with the Commonwealth this morning, the above referenced notice was filed. And that's so sketchy. It was dated yesterday. Oh, that's so sketchy. Counsel did have a second telephone call with the Commonwealth who stated that he had inquired of ADA McLaughlin. I'll never get old. As to her review of the materials was informed, she gave notice to another prosector of exculpatory evidence in an unrelated case. It's like if Jabba the Hutt and one of the evil stepsisters in Cinderella joined forces. That's what Meatball and Laura McLaughlin would be. Requested the USAG permit her to disclose the materials to that prosecutor, but that request was denied. So it's all about the he said, she said. Like, where's the proof of any of this actually happening? Any of these action steps taking place? It is counsel's understanding that a hearing on this issue will be held in Norfolk Superior Court at 3 p.m. on one or more unrelated pending cases, which was today. So again, they have a week to, I guess, figure out and maybe hear from the feds to see, can we get an extension on this? Does this order exist? Can it be produced? What, if anything, needs to be protected? And if so, why? For the reasons set forth above, Mr. Walshe requests that this motion for relief be granted. Failure to grant this motion will result in the violation of Mr. Walshe's rights to a fair trial, due process, to confront witnesses, to have effective assistance of counsel, and Mass Crim P14, those rights guaranteed by the 5th and 14th Amendments to the Federal Constitution, and Art 12 of the Massachusetts Declaration of Rights. Well, as long as the Commonwealth gets a fair trial, I guess it doesn't matter, right? Footnote. Counsel for Mr. Walshe has never been permitted to review the protective order at issue, has never been informed of what materials were produced by the USAG to the NCDO, and motions filed and heard where this and other information has been requested have been denied by this court. Larry Tipton. These signatures are absolutely sending me right now. Mr. Tipton, are you a DocuSign kind of guy, or are you a Lumen PDF? So with that, I guess we wait with Norman bated breath and see what, if anything, comes of that. So I guess we'll have an update on that within a week or so. And with that being said, if you enjoyed today's content, make sure you hit that subscribe button. Make sure you hit that notification bell so you do not miss the next video from me. And make sure you hit that like button, because that tells the YouTube algorithm that this is newsworthy news, and it is. What, if anything else, is the Commonwealth of Massachusetts potentially hiding? Now, of course, if it's true, there is a federal protective order, which I'm inclined to believe that there is, but the Commonwealth's just having everybody jump through hoops as they do. But why now? Meatball wants to play ball with the feds, probably because it serves his interests. So we'll see, but thanks so much for watching. Get some sun, but not too much sun, because skin, I'll see you in the next one.